Welcome back, everyone, to the Legacy Lawyers podcast. I'm Nathan with you today. Joining me is Taylor Stone, the one and only William Taylor Stone. And today's episode is coming to you from the locker room. We're both in t-shirts from a team building activity with our firm this morning that involved what some would say is a sport, others would characterize as a game. It's called pickleball.
Right.
So we were in matching Voyant Legal t-shirts, and we had to switch it up because we were going to get mocked relentlessly by other members of our team if we went on looking like this. So I realize most of you are not watching the video of this, which is, trust me when I say this, to your benefit. We definitely have radio faces.
100%.
So podcast faces. Taylor,
Sir.
first of all, before we dive in, let's just give the disclaimer.
Sure.
We are, last we checked, both estate planning attorneys with active law licenses. We help clients every day, all day, put trusts, wills, and other legal instruments in place.
Right.
However, the purpose of today's podcast is not to give you legal advice. So nothing that we say should or could be construed. I guess it could be, but it should not be construed as legal advice. We're in the podcasting space in the business of edutainment.
Ugh.
So
Sounds
this
gross
is
every time you say it.
Yeah, no, I love it. So I love words that get made up. So with that being said, if you have questions regarding anything that we talk about today, feel free to reach out to us. Feel free to reach out to an attorney in your area, someone with the proper qualifications and licensure to help you with your specific situation. That being said, Taylor, as a seasoned estate planning attorney, I'm sure you see lots of estate planning errors. But I want to ask you, like, if you had to name the top one or maybe the most problematic one, what would you say that is?
It's absolutely, Nathan. It would be funding. Now that term, I think
That's a weird word.
Yeah.
You think edutainment's bad.
We'll go back to edutainment.
Okay.
Funding is a concept where you are retitling assets to be held inside this trust. I think the best way to think about it is if you look at your trust as a treasure box, all right, it's just a fancy box that's been created unless you actually put your treasure into it. Okay. Now the
So you're
funding
saying
process,
funding, unless we do it, we have an empty box.
exactly. We have a real fancy box that we put together, but it does nothing unless we actually put our treasure into it. And that's what makes it the treasure box, which is the funding process, putting those assets into your treasure box. That's the number one fail that we've seen with estate plans from other attorneys, is that they miss that funding piece. And arguably, in fact, doing a little research, it's more than half of estate plans, trusts specifically, that are put together, they don't do funding. Meaning
7 out of 10 is what the stats are telling us, right?
Yeah. 7 out of 10 that we have a nice box out there that's sitting up on your shelf, no treasure in it. Therefore, you spent money to put together an estate plan. Now you have to go to probate when you pass away.
So when you say it's not been funded, you mean maybe they left one or two things out?
Or they didn't put anything into it, right?
Really?
Yeah. In fact, one of these cases, a while ago, Nathan, you and I worked on a case together where we had some clients who came in. And as is sometimes the case, where we have clients who say, okay, we put together an estate plan a long time ago, and now some things have happened in our life, and we want to see if our estate plan is still working.
Right.
This particular plan that was put together was made in a very specific way to be able to hold particular assets in such a way that they would not be countable assets for an individual going on to Medicaid. Very specific type of planning for long-term care.
So this wasn't even just a probate problem.
Exactly.
So these people were still living and assets hadn't been put in, which normally, if we're talking about just a regular revocable living trust where the objective is just to avoid probate, that's an easy fix. We catch that issue, that error, that omission, and we help them get that funding in place, and we're back in
Right.
business. But in this case, this had more immediate consequences because the trust they had created was meant to actually protect them while they were still alive.
Correct. And in fact, allow them to qualify for benefits when they would be needing them most,
Okay.
right? And for that extended period of time that they would be on that long-term care, this plan was in place that should have held things like their home, I believe some stocks may have been involved, that would have held those in such a way that they could be used to potentially help supplement that care that they would be receiving, but now couldn't be used at all. And in fact, disqualified the person from getting onto Medicare.
So, because it sounds like what you're saying is that in the Medicaid world, assets sometimes have to be in a trust for a specific period of time in order for them to be protected from a spin down.
Exactly. And I know
Okay.
we've done several episodes on spend down and Medicaid and some protection with those things. And there's a lot of nuance there. But one of the primaries, is, especially as we're creating an estate plan to assist with that, is funding.
So I'm confused though, because these clients, did an attorney help them create this trust?
They did. Yeah, they did have an attorney who created this trust. And oftentimes that's the case that we'll find, is that people have usually spent good money to have an estate plan put together. That's why it's a fancy box, right? Instead of just a regular box kind of a thing. An attorney has been paid, a licensed attorney, bar licensed attorney, to put together an estate plan for you. And then usually the funding is a piece that often is kind of handed off to the individuals.
So that's a thing that's always confused me is, I mean, I've had people look at me and say, how can an attorney in good faith prepare an estate plan that includes a trust and then not assist the client in putting the assets that are potentially going to cause a problem down the road into that trust? And what I always have to tell them is, for whatever reason, some lawyers, a lot, I would say, of estate planning attorneys view their job as simply creating the legal documents, and it's up to the client or chance or providence, I don't know, but and then they say, well, how is that not malpractice? And usually what I'm able to do is leaf through the binder where this estate plan is, and I find this empty treasure box, right? This empty box.
Right.
And right next to the empty box is usually a letter that looks like a to-do list.
Right.
But really what it's doing in this instance where the attorney doesn't help the client put assets into their plan or into their trust, is it's really doubling as a CYA for the attorney, right? I mean, it's basically, you come to me 25 years after I did your parents' planning and you ask me, why are we still going to probate? Why were assets not placed into the trust? And what they'll do is they'll pull out that letter and they'll say, well, because your parents didn't follow my instructions and fund the trust with the assets. But then when you start looking at that list, these are not things that people are familiar with. These are not activities that they like. Go ahead and try to draft a deed to take your property out of you and your significant other's individual names and retitle it in your trust. See how that goes, right? For somebody
Right.
who's not dealt, they're not in title, they're not in real estate, they're not law trained. For your, your well-educated, highly successful, highly functional engineer, that's going to be a problem. So that's what always boggles my mind, is that somehow that little letter manages to shield the attorney from problems. At our firm, we've taken the position that is our job. It is part of our job to make sure that our clients fully implement their plans and that they fund their trust, put the assets inside their trust that would otherwise be problematic. And we've built that into our process. So if you're looking to get into an estate plan and you're interviewing attorneys, or meeting with attorneys to decide who should be entrusted with that work, one of the
Mhm.
things you should definitely ask them is, what is your process for helping us fund our trust?
Absolutely. That's actually a great idea, kind of a great question that they would be able to pose to those attorneys. I
Mm-hmm.
think a lot of times, Nathan, your question about, well, why do some of those attorneys do it that way? I'd imagine too that a lot is argued off with, oh, because of cost. To say,
Mm-hmm.
look, you
They're
can
trying
do
to
this
save
on
you
your own.
money. Right.
Mhm. Right. People think, oh, I'm going to save you money by saying you just do that portion on your own. Just get the deed transferred. Just do any of those things. And oftentimes a layperson thinks, okay, I can do that and I'm saving some money. I'm little DIY. I'm knowledgeable. I'm that knowledgeable engineer, like you said. I think I can make this work. And then usually that doesn't happen. And you
And
just
so
forget.
25 years later, when engineer passes away and children start trying to wade through what they need to do,
Mhm.
they end up paying a lawyer tens of thousands of dollars potentially to probate an unfunded trust estate. Um, and then you look back and go, did we save any money? And the answer is no, we absolutely did not. So this is one of those areas where you absolutely get what you pay for and you get what you tolerate. So you should not tolerate working with a firm that does not have an integrated plan to help you fund your trust.
Mhm.
So
Right.
we've used real estate, I think, mainly as an example, but talk me through some of the other um, funding activities that our listeners should be aware of. Like, if I put a trust in place, let's just say for sake of this discussion that it's a revocable living trust and I'm looking to avoid probate.
Right.
Take me through that.
Sure. There are several in here, and again, don't want to construe any of this with legal counsel to provide to anybody here, but just kind of education about these processes.
Hmm.
Um, let's talk about bank accounts. Very common,
Okay.
right? Bank accounts are maybe a brokerage account, right?
Hmm.
Usually, what ends up happening is either you retitle that account itself either into the name of the trust, or you create what's called a pay on death beneficiary from that account into the trust, or for a brokerage account, transfer on death um, to the trust, transfer on death beneficiary to the trust. That says on our passing, these assets go directly into the trust and the trust will manage it from there. So
So
that's
then, if I'm understanding that right, like when we're talking about real estate, we're retitling by creating a new deed,
Mhm.
signing that deed, recording that deed. That house is then presently owned in that trust. But
Right.
you're saying in some cases there are assets that are going to remain titled in the client's individual names. The way we're going to solve the fact that it's not in the trust is we're going to say, but upon our passing, these assets are automatically supposed to be put into the trust. And when we say automatically, as long as that death beneficiary is named the trust, then whoever's acting as the trustee is going to be able to take proper documentation into those financial institutions and end up walking out with a check payable to the trust, which essentially avoids the probate
Mhm.
with regard
Precisely.
to those assets.
Mhm. Well, but Nathan, what about accounts kind of like my IRA, 401k? Should those then be retitled as well? I mean, funding, right? This is most important piece. Maybe I don't have a brokerage account and I have only a little bit of money in my bank accounts. So with my 401k or my IRA, should I just retitle those into the name of my trust?
You trying to trick me into saying something? That's a loaded question. Um, it's a loaded question because it involves federal retirement accounts, right? It
Yeah.
involves the IRS.
Mhm.
So that's a little bit more nuanced. We
Mhm.
would still use beneficiary designations. We would not retitle. Here's why.
Mm.
I would say in 98% of cases, we're not retitling those. Because the retitling of an IRA or a 401k or even a Roth
Yeah.
is going to eliminate, or it's going to be basically a liquidation event. That
Mhm.
account will cease to exist as a Roth or as an IRA or as a 401k or as a thrift savings plan, and it will be converted into cash. And depending on the type of account that is, um, it could result unless it's a Roth, it's going to result in some significant tax ramifications, meaning every dollar that comes out of that retirement account is going to be taxable in the year it was pulled. Depending on your age, you also might have age-related penalties if you're too young to be taking money out of that type of account. So no, we are not going to retitle retirement accounts of that type because we want them to continue to grow tax deferred, or in the case of a Roth, tax free, because taxes have already been paid on the money that's in a Roth. But we are going to use a beneficiary designation to make sure that those funds end up in the hands of either the trustee of the trust after the account holders have passed away, or directly into the hands of named family member beneficiaries. And there is, and this is a topic for another day, but there is a little bit of a difference in terms of the tax implications and the timing implications of pulling those funds out, whether they're left to a trust or whether they're left to individuals.
I think that's a perfect example, Nathan, and you presented it so well about this should really be discussed with an attorney.
Mm-hmm.
And even as
And
you kind
with
of
the financial
step through all
advisor,
that.
for that matter, like
Yes, exactly. I mean,
and we're actually seeing that a lot more.
yeah,
More and more law firms and, well, clients, I should say, are looking for one-stop shops, right? Where my attorney, my financial advisor, and my tax professional are all under one roof. And when that happens, there's just a synergy when those professionals can all work together. And so, yeah, you would have a discussion with everybody that has an expertise in that type of an account to determine what is the best way to handle those beneficiary designations.
right. You really do want that team to be working together to be able to make that best decision.
Right.
And really, it is kind of this, like you were already kind of illustrating before, it's this payoff of, okay, do we want to save some of these taxes now, or are we trying to ensure that we're kind of doing a little bit better in the future? What's the best solution here to include that we're meeting probate still, but meeting all your other goals? It's nuanced and it's not all the same for everyone, right? It's not
Right.
as cookie cutter
Well,
really
yeah,
as
it's not.
any of these other accounts.
And I probably overstated the number of, or the percentage of times that we leave retirement accounts in the client's name and just use beneficiary designations. If we're using a Medicaid asset protection trust, like the one that you mentioned, that this unfunded trust at the beginning,
Right.
there are times where, because of the situation, we have a parent, for example, of maybe advanced years who is facing a long-term care situation. We're using a type of trust that's designed to protect those assets. In some of those cases, we actually would liquidate the IRA, the Roth, the thrift savings plan, pull that money into the trust, accept the tax consequence. But in that scenario, it's because in addition to having that additional taxable income, we also have a significant amount of medical deductions because of the long-term care situation that are going to help offset that tax burden. So it really is quite nuanced. And I'm not trying to overcomplicate it. I'm just saying this is not something that you want to be winging it or trying to do it yourself without really much understanding or knowledge. We've seen people make major mistakes in this regard. So this is something that you want to seek out good counsel and make sure that you're making the best move, because once you pull the trigger on liquidating one of these accounts or determining whether or not to retitle it in a trust, for example, those are irreversible. You can't undo those.
So I think that there's other types of accounts even that, I mean, we're talking really about those retirement accounts. That's kind of the primary that we've just been focusing on right now. But I've even seen it with just trying to change a pay on death beneficiary at a bank or a credit union. In fact, had a call this morning where that was one of the questions, maybe talking to the wrong person at a credit union where they said, no, you don't want to title that into the name of the trust, or you don't want the trust to be the pay on death beneficiary. And I think what a great opportunity for our clients to see the value of being able to say, hey, Taylor, let's just chat about this. This is what they said. What do you think about this? And I can just provide that counsel, and that's included in our service, right?
Yeah.
It's not just hey, look back at the letter, figure it out. Nope. We go through it together, and we can even say, oh, what are you hearing? Great. Let's chat about it.
Yeah. And the thing that's interesting about financial institutions like banks and credit unions, unlike if I walk into an insurance agency and I say, I'd like to purchase a policy of insurance on my life, one of the things that's going to happen, guaranteed that's going to happen, is the agent is going to ask, as they're setting up that policy, okay, if you were to pass away, who should be the beneficiary of these monies, right? That's going to happen. For whatever reason, banks and credit unions never bring that up. You take 10 grand to the bank in cash and say, I'd like to open a new account here, or for that matter, $10. And you'd say, I'd like to open a new account. Nobody ever asks you who should receive this money if you were to pass away.
Right.
And yet the likelihood of somebody dying is the same, whether we're talking about a life insurance policy or a bank or a credit union, right? It's like,
It's still
there's only
100% of the time.
there's only one way out of this place, and it involves that we're going to die. So it always blows my mind. And so then you walk in and you say, hey, I don't think there's a beneficiary named on my bank or credit union account. I would like to change that. And you get a blank stare.
Right.
And so the other thing I've found is that the letter that, excuse me, the letter that the attorney puts in the front of the binder that says, hey, go retitle your accounts in a trust or put a death beneficiary on your bank accounts.
Right.
A lot of the reason that maybe that doesn't happen is because somebody, even if they were very diligent, walks in and tries to do that, and they get resistance from the institution itself. So we, again, a time where as the trusted advisor, we can say, okay, when you walk into your bank or credit union, this is what you need to take with you. This is the type of person at the institution you need to ask for. This is what you need to say to them. Here are 3 or 4 objections or dumb things they might tell you that are not true. Here's how to push through those resistance points. And here's how to know when you've got the proper result. So I kind of make a big deal about banks and credit unions whenever I'm talking to clients, because what I'd rather have is they come back and they go, why'd you make such a big deal about the bank accounts? Like, we worked with somebody that knew exactly what they were doing, and we were in and out in 10 minutes. In that case, I go, well, then you're part of the 1%. Everybody else comes back and they tell me, yeah, it took some doing to get this done, but because of what you told us, we were able to get it done. So, so that's something to keep in mind, is that we need to make sure that we're walking people through that aspect of things and arming them with the information they need to push through some of those resistance points.
Right.
What
Now
about, yeah, I was going to say, so we've talked about life insurance policies, kind of indirectly. Those, again, you can, and you should name beneficiaries. In a lot of cases, it makes sense to make the trust either the primary beneficiary or maybe the secondary beneficiary after a spouse, if you're married.
Depending on the policy, for sure.
And depending on the type of policy. We've talked about bank accounts, retirement accounts, real estate. What about business interests?
Ooh, that's a great one. Oftentimes, here's what I would say. So as we're adding business interests to a trust, great opportunity to have it in the trust. A lot of times we do what's called an assignment, which is, first, we would just say, this business is now going to be managed by, or one of its members is going to be this trust.
Or the only member of the entity.
Or the only member of that business. And also along with that is we usually make a modification to the operating agreement for that LLC or that whatever that business is. And we ensure that that trust is now the member in those private documents. Say that it's the one that's going to be managing it. It's going to ensure that the assets.
So Um, Pretty much any type of business interest, there's
Hmm.
a way to transfer it into a trust. And I think a lot of
Hmm.
people think, man, I don't really want to go through all that hassle of talking to this person or that person. In many cases, it's simply an assignment. It's
Right.
done privately and there's no fanfare, there's no back and forth. You can take that additional step. And sometimes it's a good idea to do that and actually have the entity documents updated to reflect that your share of the entity is owned in your trust. But the first step is that assignment.
Right.
As far as assignments go, we use those in other instances.
Mhm.
Tangible personal property comes to mind.
Right. And tangible personal property, real quick, Nathan, let's make sure that everyone understands that's all of the other things that kind of fill up the rest of our life. This is our jewelry and our family heirlooms and our furniture and our clothing, even these great shirts that we have, right?
Collections,
And
yes, or t-shirts.
all of these important t-shirts.
Heirlooms, artwork in your case.
Right.
Taylor is an outstanding artist.
Well, that's too
Um,
kind. Yeah. I'm such a good artist. That's why I'm a practicing attorney.
mhm, mhm,
Um, and it's for all of those other things that again are that are maybe kind of they're personal to us, but there's usually no state recording like a business, like a life insurance policy, like our deed even, or any of that. It's
mhm,
all just kind of where it privately is held. We have that's why we have what's called an assignment that says, okay, we just say any of that property, tangible personal property, and we give usually a lot of those kinds of examples to include vehicles and some of these others. We
mhm.
just say it's now owned by the trust. And it's usually in the trust itself that we say where that's going to be distributed. And we usually do that by what's called a memorandum. It's a tangible personal property memorandum, which is just a list of all that property and who gets what.
Yeah,
Kind of
giving
goes
your
beyond
trustee
that.
instructions
Mhm.
on how to disperse those items.
Right, exactly. So that's how we that's the other type of an assignment that we would do is for our tangible personal property to come back. Now, I know I touched on it a little bit, but do you think that that would be sufficient for vehicles? But shouldn't I just title my vehicle in the name of the trust?
Depends on the type of trust we're using. If it's a revocable living trust, absolutely. There's no reason not to do that. The only caveat is you can only retitle a vehicle that's paid off,
Right.
because if you have a loan on that vehicle, the financial institution that lent you the money is actually holding the title,
Hmm.
and they're holding that as a security, so they get paid on their promissory note. But as soon
Right.
as they send you that title, yes, you can absolutely go in, and you should go in and retitle that vehicle in the trust. That would be the best practice.
Hmm. Right. And that's usually what we say is just best practice. Just ensure that it's the trust that's
Hmm.
able to manage that.
Hmm.
Um,
Here's one that is a little stickier, or can be. What do you recommend when it comes to digital assets, crypto? Uh,
that one is a little bit more sticky.
mhm.
That one is, I think, I believe we already have a podcast maybe about digital assets. If not, we definitely need one. Stay tuned if we don't
Yeah,
have
I
this one
think we
already.
do, but let's touch
To
on it.
Sure. It depends on what type of a digital asset it is. And if it's, you have cold storage, if it's your cryptos, being held on a thumb drive somewhere in your home or something like that. If you're going through a financial institution or you're going through a business like I believe it's
Coinbase,
Coinbase or any of
Robinhood.
these. Right. A lot of those they actually give you an opportunity to place some sort of a transfer on death designation, power of attorney designation, just to be able to identify who is going to be able to use or take those assets as soon as you pass away. However, though, with a lot of cryptocurrency and a lot of other digital assets, this is kind of a new space. This is where we're kind of in
Mhm,
our Wild West era
mhm,
of, trying to understand the law, and the law is trying to keep up with this
mhm.
ever-changing environment. And so some places there's not a really good solution. And so this is yet another time, great opportunity to say, here's what my asset is. Let me talk to an attorney and have them say specifically for that asset for you, what would be the best thing to do.
Yeah.
And they can be able to walk you through that to make sure that it's properly held in the trust if able.
And for people that are maybe a little bit less familiar with like cryptocurrencies,
Yeah.
We don't have time to get into it in great detail, and if there isn't an episode, we definitely need one. But basically what's happening is your share or your ownership of that cryptocurrency, that electronic digital asset, it's, even though you have the codes, right, to access it, your cryptocurrency is actually on the blockchain. It's part of a computer system,
Right.
and it's going to stay there for as long as you own it. It's going to stay there forever. Even if it changes hands,
There it is.
it'll still be there. It's just somebody else will have the codes to get to it.
Mhm.
So a lot of times, and I've actually found that most, for example, Coinbase,
Mhm.
and I know this because I personally have some, does not have any way to leave a beneficiary designation on my Coinbase account. So
Yeah.
essentially what I have to do is I have to make sure that I've left my access codes with my trustee, essentially. If I
Right.
want my trustee to be able to go in and take control of that after the fact. Now, the scary part about that is if they have the access codes, they can go in and take it. So we are still trying to, and obviously we're hoping that if you're naming someone as a trustee, they're not the type of person that would go in and steal your cryptocurrency. If they do
Right.
that, you definitely need to exercise your right to amend the trust and remove them as the trustee, because you cannot trust them.
Mhm.
But what I think we're getting at is we have to get a little bit creative, and we have to find ways to say, okay, I've got a thumb drive in the safe, and you have the combination to that safe. But the only reason you would ever get into that safe is because you know that there's several tens, hundreds of thousands of dollars of cryptocurrency that
Mhm.
if I die and no one takes control of it, it's just going to sit on that blockchain and not do anybody any good.
Right.
So,
Exactly. And I think that that's a great example of, maybe I won't give them that access to that right now, but they'll
mhm,
at least know how to gain that access
mhm.
when I become incapacitated or when I've passed away.
Yeah, and I mean, if you wanted to get really creative, you could maybe create like a scavenger hunt. Here's how you go, right? And you don't release that until after you're gone, so that there's no way they could access it. But there's,
This the envelope, you break the seal, and
that's
in there
right.
it says, this is the safety deposit box that has the key to get into the trunk of the car
That's
that
right.
has also
That's right. That contains the lockbox, that contains the shoe, that when you
I'm
peel the
sorry
sole
for
off of it, the thumb drive is lodged in the heel.
I'm apologizing immediately for the Croxford children who are going to have to experience all of this for the $50
Yeah,
in that saved on
because
on
if you think
Nathan's
I just drafted a
blockchain.
regular trust for my family, like I can do anything I want in that document. Am I going to have some fun? Absolutely.
Because you're a fun guy. This is attorney level fun.
That's right. If you're
More
not
obscure in
laughing,
Kona.
then you haven't been to law school.
Right.
You have not spent enough time in an estate planning law firm, because we
For
think this
sure.
is hilarious.
It's so true. Thank you for the moderate chuckles I'm sure that a few of our clients have now experienced for us.
Yeah. So all laughing and scavenger hunt talk aside, if you have an existing estate plan, a question you should ask yourself is, I have this nice fancy treasure box that an attorney helped me build.
Right.
I need to check and make sure that there's something inside of it, because unlike a will, for example, is just a general statement of what you want to have happen to all your things. And the reason that that works is because it has to go through a probate, and a judge has to supervise the handling of all of that. The
Exactly.
way around that is to use a trust, but a trust works differently. A trust can only control what is contained inside of the trust, what's contained inside of the treasure box. So if you already have a trust, it's a good idea to have a great estate planning attorney take a second look at that, make sure that it's up to date, that it's current, that it's going to work properly, and importantly, that it actually contains the assets that you built it to contain in the first place. And if it
Precisely.
doesn't, go through as you listen and kind of tick off all of those major asset classes that we ran through, and go through one by one and make sure that all of those funding exercises have been completed. If you're
Right.
not finding that you're getting the proper help doing that, then consider finding somebody else to work with, because that's the sign of a good quality estate planning attorney, or a good quality estate planning firm is they're going to link arms with you. They're going to walk side by side with you and make sure that your plan is fully implemented. Your assets are all accounted for inside of that trust. And that when you walk out of there, there's a nice bow tied on top of it. And then keep in mind that sometimes that bow is going to come untied, right? You sell a house, you move. What do we have to do? We got to redo the deed thing, right? So as time goes on, we have to understand that this is an ongoing process. It's not a one-time deal.
Absolutely. I think that you hit a lot of these for real estate. Sometimes, what if you if you get a new mortgage on the home, right? Usually they require you to sign it, take it out of a trust, renew the mortgage, and then oftentimes we forget to put it back into the trust. We've seen that countless times.
Not we don't.
Oh, that's fair. We've
the
seen
title
that company
or the lender, they're happy to help you take it out of the trust because they want you to close on that loan so they can make their commissions and their fees. And then they're not so interested in helping you make sure that it gets back into your trust. So if you've ever done a refi and you think that your property is owned inside of your trust but verify, right? Trust but verify.
Right.
Check and make sure, because how many times have we seen probates that resulted from somebody refinanced their house, thought that their home was still owned inside of their trust after the refinance, and their children found out the hard way by going through an entire probate that somebody missed a step. So don't just take that for granted.
How many times have we seen that? Too many times. So
many times. Yeah.
And that's really bringing us back to that original story. It was the deed. It was the major asset that a lot of us have throughout this life is going to be our home. It's going to be that real property, and making sure that it's inside of that treasure box is just key. If you're not able to do it, if you haven't done it before, a lot of the websites that you can go into for your county that actually holds your deed, you can often go on and just look at it yourself. I know that I do that for a lot of the clients, right? Especially if you're down in Utah County, it's a free website that you can just be able to go on, plug in your information, and you can look at the deed and see, yep, it's in the name of the trust, or wow, that one actually got out of that trust.
Or if you're old school and you don't want to try to deal with a computer, walk into the recorder's office in the county where you live and say, I'd like to see the most recently recorded deed on my property. And for a few bucks, they will provide that to you. It's public record.
Yeah. And usually the few bucks is that they'll actually print you a copy and give it to you, right? So you can say, here it is, definitive proof, I now have this. Good counsel. It's good counsel to just give it a whirl, give it a look, to be able to say whether or not this is actually being held in your trust, if you have a trust at that time.
All right. Any parting thoughts before we wrap this one up?
No, just think about it. If you have an estate that involves a trust, think about it as a treasure box. Now, ask yourself the question, is this just a fancy box, or is it a treasure box that has treasure in it? Because if it doesn't have treasure, it's a really expensive fancy box that actually doesn't avoid probate.
Yeah, it's going to do nothing. It's a pretty thing to look at from the outside, but it doesn't have any function and might as well have not ever created it in the first place if it's not funded. So, all right. Thanks everyone for listening. You can check us out on all the major podcasting platforms, Apple, Spotify, YouTube. You can find us on our website, buoyantlegal.com. And we appreciate you listening, and we will catch you on the next one. Thanks, everybody.
All right. See you, everybody. Hopefully with better t-shirts.
There we go.
You've been listening to Legacy Lawyers with Michael Haslam and Nathan Croxford. We give you the juicy detail of cases that our law firm has dealt with. We take out the lawyer talk and legalese and show you what options some of our clients had to choose from to fix their situation. The effects of not doing planning can be devastating. We'll be back soon, but in the meantime, hook up with us on Facebook and Instagram at Voyant Legal. Call us at 801-951-0500 or send us an email at team@voyantlegal.com. And for commonly asked questions, hit voyantlegal.com/resources. We'll see you next time.